Welcome, boot campers, to today's content. The topic is Dispute Resolution Part 1 for those medical bills denied for compensability, extent of injury, relatedness, or liability. The acronym is CERL that we use. This is day 5 of our boot camp series, and this is part 1 of a two-part series on medical bills denied for CERL. And we're making our way through the boot camp obstacle course. So we are headed to the swing exercise. I think if you're swinging from one swing to the next, thinking you've got a bill, you've got pre-authorization for those services, and you're swinging the bill to the carrier, it can get a little dizzy unless your core strength is good. And understanding denials for compensability, extent, relatedness, and liability is part of your core understanding of workers' comp. We want you to learn when an insurance carrier is liable to pay for medical services in the workers' compensation system. Understand what it means when an insurance carrier denies a medical bill for compensability, and be able to know what form to use to pursue dispute resolution if you extent, relatedness, or liability. So that is our topic. It is part 1 of a two-part series on medical bills denied for CERL. A little disclaimer, and that is we are trying to educate system participants, but ultimately it is your responsibility as a system participant, a healthcare provider, or an insurance carrier, whatever representative you are, to learn the statutes, those are the laws, and the rules, also known as the Texas Administrative Code. We have two statutes, the Insurance Code and the Labor Code, that apply to workers' compensation system, and the Administrative Code. So if there was ever a discrepancy about what we've presented here, the rules and the laws will help resolve that dispute. So know your laws and your rules. An overview of what we're talking about today in this webinar is we're going to talk about the definition of compensability. That is important. That is basically what is accepted or covered in workers' compensation as far as those claims or injuries or illnesses. What happens after the injury? There's a notice of injury, and then potentially there are disputes after that. We also want to talk to you about how you may be able to avoid a medical bill being denied for a CERL reason. Sometimes these denial reasons are unavoidable, but we're going to give you, as best we can, some best practices to try to avoid this and know ahead of time what you're getting into. And then if you do get a bill denied, identifying the medical bill when it's denied for compensable extent, relatedness, or liability. And then the next steps once you get that medical bill denied for CERL and the dispute paths you'll take. And then some resources from the Division of Workers' Compensation. So let's start with a real basic concept, a core concept that you need to get strong in is what is a compensable injury? And that is an injury or illness. It could be psychological only, it could be physical, it could be an occupational disease that arises out of and in the course and scope of employment. Then you have an accepted claim in workers' compensation. So compensability is the claim resulting from something that happened in the course and scope of their job. So what does course and scope mean? That is sort of a two-pronged approach. Basically, it's an employee that is doing something you required them to do, and it also furthers the affairs and the business of the employer. It can be on the premises, it can be off the premises. So maybe they're traveling or in transportation. It doesn't have to be on the premises. Your employee could be in another state. I travel for work. Sometimes I'm in another state. So yes, a compensable injury can occur as long as it's in the course and scope of their job. Why is it important to understand this? Well, that is because workers' compensation insurance carriers are only liable to pay for A, medically necessary care, and B, for a compensable injury. So if you overcome those two hurdles, then it's less likely your medical bill will be denied payment. The insurance carrier can dispute the compensability, the extent, relatedness, or liability. That's their job, is to investigate each one of these claims and to look for any um, exception to liability that they may see in the records that they receive and the notices of the injury that they receive. Insurance carriers for workers' compensation are not responsible for ordinary diseases of life and injuries that don't occur in the course and scope of their job. So they have a responsibility to look at the records and the notices that they receive. CERL, or compensable extent relatedness liability disputes, are often called benefit disputes in our system. So sometimes the insurance carrier, even if the injured employee had an injury on the job, they may not be liable. There's 6 exceptions found in 406.032. That's the Texas Labor Code exceptions. Here are 3. There are 6 of them. Maybe they intentionally caused their own injury, or there was intoxication involved, or they were participating in off-duty voluntary, baseball tournament. Those can be exceptions to liability that the carrier is going to be looking at and investigating that claim. So typical compensability disputes, that means they're not entitled to this compensable claim. It didn't happen in the course and scope. So these are typical type of compensability disputes, and that is whether the injury or illness or condition, or even possibly a fatality, was caused by work activities, or was the condition you're treating one of those exceptions to liability. So those are some typical reasons why the carrier will dispute compensability or liability, the C and the L of CERL. So it's important for you to know about these types of disputes as fast as you can. A healthcare provider may not know about the CERL issues until after you've provided a medical service, and then you get an EOB, or explanation of benefit, back with a denial code on there that is one of those C, E, R, or L reasons. Sometimes you can find out before the services are provided through pre-authorization. On that approval, carriers are supposed to let you know of any unresolved issues of C, E, R, or L. So understanding this process and finding out as soon as you can about outstanding disputes from the carrier side will help you either avoid them or resolve them as quick as you can once you know about them. So it can happen after or before your services are provided. So once an injury or illness occurs, the first report of injury is filed by the employee. So the employee is going to notify the employer not later than the 30th day after the date on which the injury occurs, or a notice to the employer of injury, or it could be an occupational disease. You can find more about that notification by the injured employee in our Rule 122.1. So if you go to our topics A through Z and you go to R for rules, you can go to chapter 122 and learn more about the employee's duty to report their injury. Now, for the employer, they're going to receive that notice, and then the employer has a duty to turn around and file the DWC Form 001. That's the employer's first report of injury or illness to the insurance carrier. And we advise the employers to do that as fast as possible so that the insurance carrier can begin their required actions. So, generally speaking, within 8 days of the employee's absence from work for more than 1 day, or when they receive notice of an occupational disease. So that's the employer's duty. Find more about that in Rule 120.2. That is the employer's first report of injury and notice of injured employee rights and responsibilities. So that's the employer's duty next. And then the insurance carrier. So it goes from the employer, to the insurance carrier. So the insurance carrier's first written notice of injury, or NOI, is the earliest receipt of receiving the employer's first report of injury, or we notify the insurance carrier, or if no employer first report of injury has been filed, any other communication that comes to that carrier, regardless of the source, that fairly informs the carrier, the name of the injured employee, the employer. And this is again where the injury occurred, where they were working or who they were working for at the time of the injury, the approximate date of the injury, and information that it was work related. So, for example, your medical bill could be the insurance carrier's first indication that there might have been a workers' compensation claim. So the carrier must follow Rule 124.1F once they receive your bill, by contacting the employer within 7 days of receipt of that medical bill. So if you feel like the carrier has not contacted the employer to establish that claim, that they should have done it within 7 days of receiving your bill, you can file a complaint with us. It's at the beginning of an injury. Sometimes, that first step, second step, third step is going to take a minute, and sometimes your bill is going to be the first thing that they see. So upon receipt of that written notice of injury, the insurance carrier begins their duties, which is, of course, investigation. Did it happen in course and scope, which is the compensability of the injury? Are they liable for that injury? And they need to start paying benefits, maybe perhaps temporary income benefits, and of course, medical bills that they're responsible for. So if the carrier says, I'm looking at this and I believe that this injured employee does not have a compensable claim, they believe it didn't happen in the course and scope, or they were intoxicated, some other liability exception was met in their eyes, in the carrier's eyes, they can issue a notice of denial for compensability, liability, and refusal to pay benefits. This is called a PLN01, or plain language notice number 1. And the carrier, according to our rules, has to submit the PLN1 to the division and to the claimant, which is your patient. Notice on here, it doesn't say it's coming to you, healthcare provider. That's why it's important for you to ask. However, on the insurance code side for the networks, insurance code, that's the statute or law. 1305 is a chapter that covers workers' compensation certified networks. This is when you have a contract with the network. There is a special perk there, and it requires the network to notify you, the network healthcare provider, when the carrier is contesting the compensability. It's not on the non-network side. It is on the network side. So if you're a network provider treating a network claimant, you're going to get notice when they're filing the PLN1. Non-network claims, you need to ask and ask the adjuster and ask different people, trying to find out if there was a PLN1 filed. So if a PLN1 was filed by the insurance carrier between the 15th and 60th day after receipt of the NOI, notice of injury, so the carrier is liable and must pay all medical services prior to filing that PLN1. So if you get a copy of that PLN1, find the date on it and see when they filed it and when your services were. They could be responsible even if the carrier ultimately wins that it wasn't compensable. So present this information during any kind of reconsideration or during a proceeding like a benefit review conference or a contested case hearing. So get a copy of the PLN1 if you can. That's what it looks like on the left there. And also you can read about the 15th and 60th day in Rule 124.3A. That's investigation of an injury and notice of denial or dispute. Now, if the carrier files a PLN1, that is not final adjudication. That is not your cue to say, I'm going to start billing the patient. That is just the carrier saying they are contesting compensability. We're going to teach you how to go through the dispute resolution process after a PLN1 is filed. So on the network side, again, 1305.153 is called provider reimbursement. The insurance carrier shall notify in writing the network provider if they're contesting compensability. So you get it. You get that notice. And prior to providing that notice to you, they may not deny, the insurance carrier may not deny for medically necessary healthcare services, your medical bills, based on compensability until they've filed it and they're responsible up to $7,000 in reimbursement for any medically necessary healthcare services. So on the network side, you're going to get notified, and the carrier has to pay medically necessary services until the minute they file that PLN1. So on the network side, you have a dollar amount, and that's not charges, that's reimbursement amounts. So if you know, strengthen your core and know those all about the PLN1, that'll help you with any dispute resolution there. Now, the next type of dispute I'm going to talk to you about is extent of injury or relatedness, the E and the R in the CERL. And that is when an insurance carrier is reading information like medical records or maybe in investigation files or whatever they're looking at. Example, a medical bill or your medical records that went along with your medical record, your medical bill. They can look at your diagnosis codes and they may dispute whether the injury, illness, or medical condition was caused by or extends from the original work injury. So in this case, they've accepted something, a condition, an illness, but then they see more diagnosis on your medical bill, which you should code what you treat as long as the patient's saying it's part of their work-related injury, and the carrier, can question it. This can happen during the life of the claim. It is something the carrier, again, is responsible for looking for things that they shouldn't be responsible for, like ordinary diseases of life, and whether the treatment, so they may even look at the service that you provided and say it's completely not related to whatever the injury is. They may deny because the service you provided is not related to a shoulder injury. So that's the R part. So one is about the diagnosis codes. The second one is about the combination of the treatment to the diagnosis codes. So this is a extent of injury or relatedness denial. And they filed that notice of denial on a plain language notice number 11. This is a PLN 11. So we ask that the carrier, we don't ask, the rules require that the carrier file this no later than the earlier of the date the carrier denied your medical bill, or the due date in which they should have paid or reduced or denied your medical bill. So if you're getting an EOB, explanation of benefits, that says from the carrier, we are denying you for extent of injury or relatedness, there should be a PLN 11 on file. You can ask for it. If there wasn't one on file, that could be a violation on the carrier's part. So if they're going to say it on an EOB, there has to be an official PLN 11 out there. So a lot of people call and say, well, they've been paying the bills and all of a sudden they're not paying the bills for extent of injury. A PLN 11 can be issued at any time during the life of the claim. Remember, they're looking at all the documentation that you send and any other files that they have, and they're looking for any new information about conditions being treated or services being rendered. So PLN 11s can come at any time. Usually PLN 1s are usually at the beginning of the injury, but once the claim is established, PLN 11s can come later, or maybe they don't come at all. You're treating the accepted injury and nothing else pops up. Now, there's a caveat to what the carriers have to pay. And this is related to a designated doctor. When the injured employee goes to a designated doctor to settle extent of injury issues, so they can have an official exam by a specially trained doctor that's never seen them before, right? A designated doctor, those are our specially trained doctors. If the DD, designated doctor, determines the conditions that were previously denied by that carrier, saying that these conditions, these XYZ ICD-10, are not part of the accepted or compensable injury, if the DD determines, well, yes, they are, I'm the expert and my opinion has presumptive weight, then the insurance carrier must reprocess and pay all the medical bills previously denied for the reasons inconsistent with the findings of the DESDoc. So the DESDoc's opinion is important, especially about extent of injury. The insurance carrier has 21 days from the receipt of the DD's report to reprocess your bills. That can be found in 127.10, that rule, general procedures for DD exams. So how do you avoid a medical bill denied for compensable extent, relatedness, or liability? Some are unavoidable, but we're going to try to give you some best practices to at least know about it ahead of time. So your registration and intake, every time the patient comes, is the is the treatment you, patient, are seeking is due to a work-related injury? Are you asking every patient that walks in the door whether it was work-related or not? If you're not, that is probably a good thing to do. Ask all patients and get this question answered in writing from the injured employee. It may help to ask this question differently. So, say you have it in writing upon registration or intake, but then they go back to the room, to the exam room. Those questions are going to come up there, like what were you doing during this injury? Where did this occur? That can prompt the injured employee to say, well, maybe I was at work. I was at work. So, everybody from the front desk to the clinicians, um, to the checkout staff need to be asking these questions. I think it's important, it's healthy, and we want to try to avoid finding out way after the fact. So ask the injured employee if it's a work-related injury. And once you've established that it is work-related, you can ask the injured employee whether they have any outstanding disputes on CERL. That's a PLN 1 or 11. Now, the injured employee may or may not know what that means, but you can ask them in more plain language. Has the insurance carrier told you that you are not entitled to workers' compensation benefits? Remember, the carrier is supposed to send a copy of the PLN 1 uh, and 11, if there's an 11 for that claim, directly to the claimant, which is your injured employee. You can ask for a copy from the injured employee. Also, if you're getting a referral from another healthcare provider, say you're the orthopedic office or you're the physical therapy clinic, you're going to ask the referring provider. If you find out it's workers' compensation, you want to ask, are you aware of any disputes on compensability, extent, relatedness, liability? If they say yes, ask for what conditions have been disputed. Ask for a copy of the PLN 1 or 11 if they have one. Remember, the carrier's not supposed to send it unless it's a network claim. And do they have medical bills denied for any of these reasons? If yes, then has that treating doctor pursued dispute resolution? Have they gotten an outcome? So you want to ask those questions. If there is an outstanding dispute over CERL, will the treating doctor help with causation information and will they help participate in dispute resolution? So that there's a whole set of questions that you can ask the referring healthcare provider. Also, your interaction with the carrier's adjuster. You want to keep a rapport going with the adjuster. You can ask them if there are any outstanding disputes on CERL. And if there is, you can ask for a copy of the PLN 1 or 11. The adjusters don't have to send it to you unless it's a network claim. They do have to notify you for compensability disputes. But you want to get a copy because you want to read it and know what conditions and diagnoses are being disputed by the carrier. And that way you know ahead of time. So the only way you're going to know for sure ahead of time is if you're a network provider treating a network claimant, or for all types during the pre-auth process. The carrier, if they're going to approve pre-authorization, that's only saying that it's medically necessary. But they also can have a little caveat at the bottom that says, but we think these conditions you're treating are not do not extend to the compensable injury or whatever. So there could be outstanding disputes on compensable extent related to liability on your pre-auth approval. Remember, pre-auth approval just means they can't deny you for medical necessity. They can deny you for compensable extent related to liability later. So read your pre-authorization approvals very carefully so you know ahead of time. So those are the things you can do to try to avoid. Now, if you've provided a service, you send out a medical bill, and you've received an EOB, you need to be able to identify what the reason for denial is and see if it is a CERL reason. So the communication, we have this rule about communication between you, the healthcare providers, and the insurance carriers. It is Rule 133.3. So the communication between the carrier to you, it must be sufficient. So that means your EOB must be sufficient and specific enough for you to understand why they're denying and what you can do to resolve the denial. It can be made by telephone, electronic transmission, or mail or personal delivery. And they have to maintain documentation of those communications. So, both ways, you guys need to communicate to each other and not use very general terms. So, giving the healthcare provider enough information to understand that it was denied for extent of injury or relatedness and the reasons why. Which brings me to your EOB, explanation of benefits. The insurance carriers are required by our rules to use standardized coding, meaning they have to use standard reasons for denial. These are called claim adjustment reason codes, or CARCs, on their explanation of benefits. It has to conform with our rules 133-500 and 133-501 if the total amount paid is not the total amount charged. So they're going to be using something to tell you what they did. And that's also included in 133.240 medical payments and denials for paper. And if you are billing electronically, electronic EOBs. So these remittance codes or CARCs, you can find more about that for electronic billing in the 133.500. Also, if you just want to read the list of claim adjustment reason codes, it can be found at a website. Remember, these are nationally standardized codes that are used across the country. It's not just for Texas, but you can find it at x12.org. Look for the external code list 139. That is the list of claim adjustment reason codes that the carriers must use on their EOBs. However, the insurance carriers, once they use that main CART code or CART codes with an S, they can supplement with additional text or narrative description. Remember, we want the communication between them and you to be clear and sufficient for you to understand why they're being denied. Here are some claim adjustment reason codes that relate to CERL. So 219 is one of the codes, and it says based on extent of injury. Or P2 might appear on your EOB. So it's not a work-related injury or illness. Thus, it's not the liability of the workers' compensation carrier. Or they're trying to tell you that it's already been adjudicated as not compensable. Or they're investigating the claim. Here are some of the codes, the CART codes that they can use, but the supplemental descriptions may add a little bit more information, like the services you rendered were not related to the compensable injury. So read your EOBs very carefully. If you're calling into Comp Connection to say, my medical bill's been denied, one of the first things we're going to ask you is to look at your EOB and tell us what it exactly says, because that's really important to get you to the right place to resolve that information. Also, big note here. Just because the carrier has said something, you have to make sure that it's finally adjudicated by the Division of Workers' Compensation. The carrier is not the final say. They can dispute it, but there's a dispute process to go through. Let me show you an example of an EOB denial for compensability. This is P6. It says based on entitlement to benefits. They're thinking the whole claim is not compensable. So in this case, they used P6. And on the PLN one that matched that, they will explain. So if you get a copy of the PLN one, you can see what they say about their investigation, that it didn't happen in the course and scope of their job, that you're suffering from an ordinary disease or condition of life. So this is your explanation. Getting a copy of that is important, and you'll see the date on there also. Let's go to an EOB denial for extent of injury or relatedness. This is physical medicine, PT, being offered to this injured employee. And in 246, which is the code they're choosing, is the treatment or services have been determined to be unrelated to the extent of injury. And they're also trying to tell you that final adjudication has not taken place. Final adjudication is the term we use when the Division of Workers' Comp resolves these disputes. So this is the matching PLN 11 for that denial. And if you get a copy of it, this is what it's going to say. It has a checkbox that some of your medical conditions were caused by your work-related injury. And it says we don't agree because of these reasons. So this is important for your doctor to read, for your clinical people to read, your pre-auth people to read, to know what is being accepted and what isn't, and to talk to the patient about that. This is when the doctor is talking to them about whether those conditions are part of the injury. If the patient and the doctor believe that, then dispute resolution will you can put a causation report together and go through the dispute process with more support that way. So read your PLN 11. So what's next after a denial? Do not bill the injured employee. We also call that pursue a private claim. Unless there's been final adjudication, that is a piece of paper from the division for that condition or related services. So it's going to tell you, we've looked at it, we, the division, and we've decided X. So once you get that decision that says this is not work related, then you can go about your business of billing whoever at that point, but you have to have a decision from us. And so if you don't and you bill the patient without final adjudication, you can be in violation of 413.042. That's called private claims administrative violation. So don't bill the patient so quickly without final adjudication. And that is where every party gets to have their say in a proceeding, and then we make decisions from there. And we'll get into all the details in part one and part two. Mostly part two, we'll get into the details. Just what I've been saying, the EOB is not final adjudication. It's a decision, an order issued by DWC that's no longer final, means it's no longer appealable. So the appeal timeframe has passed and no one has sought an appeal, then that makes it final. And it's obtained through the benefit dispute resolution process. Remember, we said these CERL disputes are benefit disputes. They do not go through medical fee dispute resolution because this dispute is not about fees. This dispute is about compensability, that's course and scope, extent of injury, that's about diagnosis codes, and it's perhaps about the relatedness of a service or liability. These are not fee disputes because if you have a medically necessary service that is compensable, then you might have a fee dispute. Other than that, these two first hurdles of medical necessity and compensability do not go to fee dispute resolution. So don't file a Form 60 if you have a CERL dispute or denial. What we want you to do is to develop a position statement with any necessary causation or relatedness information. So say your doctor reads that PLN 11 and he or she gets that information and goes, no, I believe it's this, then they need to start putting their position statement together. And, that is a doctor's expertise that we rely on, especially the treating doctor. They know their patient inside and out. They've had those conversations with the patient. And we want you to attempt to resolve the issue with the injured employee and the insurance carrier by requesting reconsideration, especially if the doctor's put together a position about whether he or she believes it's part of the injury. So the reconsideration steps can be found in 133.250. Generally, within 10 months from the date of service, reconsideration is that's the time frame to do reconsideration. So what's next after a denial for CERL? So if you've asked for reconsideration, you can follow the DWC benefit dispute resolution process as a subclaimant. So the claimant is the patient. You can become a subclaimant if you want to pursue dispute resolution. You're going to have to establish yourself so you can step into the shoes of the claimant as a subclaimant. So a healthcare provider going through benefit dispute resolution is called a subclaimant. The rules that you'll be following that you need to be familiar with are 140.6, that is establishing your rights as a subclaimant. So read about that in 140.6, and then requesting a BRC, Benefit Review Conference. The steps can be found in 141.1. And the form that you would use to request that BRC after your reconsideration is a Form 45. If you go under F for forms, they're in their sequential order. So you can go down to the 045. That is the form you'll be using to request a benefit review conference. We'll get into the details about that in part two. Some of your helpful resources. we put a new document, it's been out there maybe a year or so, about your dispute paths. I talked a little bit about this, but this is on the healthcare provider page. And it starts with some of the main questions we get asked in Comp Connection. I have a medical bill and I've been denied and I've done reconsideration. The three main areas of dispute paths that you would go down are, is this a medical necessity dispute? Is this a dispute over CERL? Or if those two things are not on the table, then everything else falls under fee dispute. But do not file a fee dispute if it's a CERL dispute. So these are the forms and these are the processes to follow for your main three types of reasons why you would be denied. And this is on our webpage, and I'll show you where that is real quick. So your healthcare provider page is here, right under the main workers' comp tab. Healthcare providers here. We've got 9 picture tabs here. Medical billing and denials. It's under this tab. We have all kinds of information for you here. Disputes versus complaints. Step for dispute resolution. That's this picture right here that we're looking at. Medical necessity dispute resolution. Benefit dispute resolution. It's got all kinds of information for you, healthcare providers. If you call Comp Connection, we're going to be pointing to that section. So get to know your healthcare provider page. It is a world of information. There is that one pager there under medical bill and pre-authorization denials that will give you the steps for dispute resolution, benefit dispute resolution, which is CERL disputes. So to kind of go over what we've talked about today, we talked about what it means to have an accepted claim or compensable claim, compensability, notice of injury and disputes, kind of how that works, avoiding CERL disputes or denials. And if you do have a medical bill denied for that reason, you know which dispute path to go down, and then the next steps and the proper dispute path, and then some resources that are on our website. So it's time to see if we can train your brain and flex your knowledge. Question number 1, is the insurance carrier, this is the workers' comp insurance carrier, only responsible for paying medically necessary medical service for a compensable injury? And that is true. The workers' comp insurance carrier should not be paying for ordinary diseases of life, only those injuries or illnesses that are happening in the course and scope of their job and that are medically necessary and related to the injury. So the answer is true. Number 2, is the insurance carrier liable to pay for medically necessary services prior to a PLN1 is filed? And the answer is true in some cases. Remember, we have those slides that tell you on the network side, $7,000, and on the non-network side, anything between 15th, 60th day, those medical services prior to that. Number 3, is the insurance carrier responsible for notifying the healthcare provider on the pre-auth approval letter of any outstanding disputes on extent of injury, relatedness, or compensability? And that is true. Thank you. Most of you got that right. Number 4, if the insurance carrier provider, if the healthcare provider obtains pre-authorization approval, can the insurance carrier still deny payment for the reason of extent of injury? Yes, most of y'all know that because it's probably, maybe happened to you. So 85% of you got that right. And number 5, can a healthcare provider bill the injured employee if they receive an EOB stating the medical bill is denied for compensability, entitlement to benefits without final adjudication? So can you bill the patient? That is false. You cannot bill the patient. If you have questions, still confused, you can contact us at Comp Connection 800-252-7031, option 3, or you can email us